Good afternoon, ladies and gentlemen. We are here this Saturday going live talking about how you, as a domestic violence victim, can fight attorney misconduct. Basically, how you can fight off the false claims of your offender, how you might possibly be able to do something against an attorney who may be filing false litigation on you, seeking to help your ex partner achieve some type of objective. Maybe it's going to be to get an order of protection dismissed, maybe to get you arrested, maybe to get custody of your kids, whatever it might be. But the whole objective of this show today is to give you some guidance, not as an attorney, but as an educated victim who has unfortunately gone through a lot that might empower somebody else that they may not know what to do in the future if you have an ex partner. Hold on. Abuse. I'm sorry, I'm doing something because I do this for a reason, so I got to make sure I connect it to that reason. People, bear with me for 30 seconds, not even 2 seconds. Got it done. Okay, and that looks like that, right? Yes. Yes. Okay, so today we're going to talk about how you can stop attorney misconduct. What is the definition of this conduct? We're going to go, for purposes of this broadcast, I have to say some people who may see this broadcast might not be in the state of New Jersey. The rules and the standards that are used in this broadcast will be from the state of New Jersey. If you are not from New Jersey, I recommend that you use Google. Google is the new Oracle of Delphi, people, and use search terms like rules of court, rules of professional conduct, attorney conduct rules, etc. These will teach you the guidelines and the rules that attorneys and courts have to go by in order to give you fair process in court so your rights are not violated. So if you are involved in any domestic situation, hell, if you're involved in a criminal situation, my recommendation is not to throw all of your faith in a blind lawyer who you may hire. You should take some time, learn what the hell is going on, so at least you can educatedly make decisions because you know what's going on. Then you can't be mad if someone lies to you. If you take the opportunity to learn for yourself, you can learn a lot. So, for purposes of this broadcast, I have to say two things. One, I am not a lawyer, so do not take anything I'm saying in terms of legality because I am not advising you. I'm simply explaining to you my situation based on the fact that I am a seasoned and experienced victim of domestic violence, having been stalked by a woman for 3 years. The next thing is the rules and regulations I will and submit are from the state of New Jersey. So if you're not in New Jersey, some of these rules and regulations and court proceeding standards may not apply to you. But if you go to your state's website or Google and you Google rules of professional conduct, state bar association rules, rules of court, you will find everything you need in order to do the same thing I'm going to teach you today. So we're going to again at the New Jersey Court's website, where I found all of the information I needed for this broadcast. The New Jersey Court's website has something called many things up there. But the main thing you will find up there for purpose of this broadcast is the New Jersey Rules of Professional Conduct, which are the rules governing both prosecutors and attorneys as it relates to court proceedings. They have rules in there for what a prosecutor is supposed to do. They have rules and regulations for which attorneys are supposed to abide by. And a violation of any of these rules of professional conduct in New Jersey is Rule of Professional Conduct, 8.4, called misconduct. What is misconduct? Professional for misconduct for a lawyer, 2A. Violate or attempt to violate the rules of professional conduct, meaning that if an attorney violates or attempts to violate any of the rules set forth in the rules of professional conduct, guess what? He's in violation of the rules of professional conduct, and that is misconduct. Also, knowingly assist or induce another person to do so, basically meaning if they help somebody do it or in some way induce them to do it, they're guilty of misconduct. Lastly, do so through the acts or another. Like if they think they smart and they have somebody else commit an offense of misconduct, no, you're not smart. You caught, we're going to cite you with misconduct. Misconduct is generally punishable by citations from the board, suspension, revocation, etc. like that. This is how you get an attorney removed, cited, or fired, or even his license suspended. You have to prove that this attorney violated their state's rules of misconduct, either under state or federal law. The best way to do that is to learn their rules of professional conduct and find out how legally they did this to you. So people know I'm a victim of domestic violence. So you have the fortunate experience of hearing me tell my tale as it's true, and I'm going to be able to back it up with evidence to show you what happened and show you what I did to combat the person who was doing this to me. So, again, we're going to read misconduct. We're going to start off with in New Jersey, misconduct under 8.4 constitutes 7 sections, lettered A through G. A is if you violate, I just read that. B is to commit a criminal act that reflects adversely on the lawyer's honesty, trustworthiness, or fitness as a lawyer in other respects. So to commit a criminal act that would affect a lawyer like that would be fraud, records tampering, theft, etc. Those are all crimes that would immediately make a lawyer guilty of misconduct because lawyers are entrusted to not do stuff like that. So we're going to go forward to see. Engage in conduct involving dishonesty, fraud, deceit, or misrepresentation. Again, people, the things that lawyers are not supposed to do because lawyers are the guardians of the law, which means they're supposed to represent the truth in whatever capacity they choose to be on. To the best of their knowledge, they're representing what they believe to be the truth. A prosecutor who prosecutes a defendant is representing the interests of the state and trying to keep people safe. A defense attorney who represents a defendant is trying to keep that victim's interest safe from the state that thinks he did some shit. This is the whole purpose of it, man. And the judge's whole job is to decide that. The jury comes into play when they believe they need the opinion of regular people of the person's peer group, whatever that is. We know that doesn't work like that, but whatever. So D, engage in conduct that is prejudicial to the administration of justice, people. That means that they engage in anything that can make a prejudicial verdict in a trial or a decision. Anything that would adversely affect a judge's decision that is untrue or unjust, that is a problem. E, state or imply an ability to influence improperly a government agency or official to achieve results by means that violate the rules of professional conduct. Basically, if they scam a government agency, they're guilty of misconduct. Knowingly assist the judge or judicial officer in conduct that is in violation of the codes of judicial conduct. That means if they help a judge or they help a judicial official do some negative stuff, they in violation of misconduct. Lastly, engage in a professional capacity in conduct knowingly discrimination because of race, color, religion, age, sex, sexual orientation, national origin, language, marital status, economic status, or handicap where the conduct is intended or likely to cause harm. So basically, if attorneys discriminates against you in any capacity involved in a criminal proceeding, they are guilty of misconduct. So this is New Jersey, and this defines attorney misconduct if they are guilty of any of the 7 enumerated, no, they're not enumerated, they're alphabetized, subsections of the title of the Rule of Professional Conduct 8.4. So now we're going to scroll back up, and we're going to go to rules of professional conduct that have to deal with, I would say, providing false testimony and false records. Because for the purpose of my example, that's what I'm going to use today. Because I have an excellent example that is, again, the truth. So we're going to go to rule. Why don't I see this? I know where it is. 1 second, my audience. It is, I believe. Oh, damn, that's not it either. 4-4. Damn, I thought that was it. Wow, people, I'm doing something dumb today. What am I doing wrong? Hold on. I thought it was rule 4-1, people. I could have swore it was. I believe it is rule 4-1. What's going on today? That's weird, people. No, that's so weird. This is the rules of professional conduct. That's weird. I could have swore this was here. RPC 4-1. What's going on here, people? I'm having one of those days. Okay, I might have confused the statue I'm looking for, but for now, we'll hold off on that. So, people, I went to Google. I find that out. Now, the next thing you do if you want to prove misconduct, because remember, you have to prove that the attorney violated in some way. He violated either the rules of professional conduct of that state, whatever it might be, because it may not be called that in your state, or if he violated some criminal statute. So the next thing you need to do, and you go to Google, and what you would do is look up your state's code of criminal statute. In New Jersey, it's called the 2023 New Jersey Revised Statute, Title C, the New Jersey Code of Criminal Justice. And this is every charge you can legally, criminally be charged with in the state of New Jersey. Now, this goes for you as a private citizen or an attorney, as either a prosecutor or an attorney. They are still subject to many of these, except prosecutors who have prosecutorial immunity, unless you can find a way to show that they messed up, and you can pierce that immunity by showing they messed up. That's not the conversation of this broadcast today. The conversation is how you can deal with an attorney who may be illegally violating your rights. So we go to this, and there are several sections that have to do with violations for an attorney. All is here, but we're going to go for purposes of this. I really wanted to go to the rules of professional conduct 4.4. That kind of has me, people, because I knew it was there. This is rules of court. See, that's why, people. I know why, because this is the rules of court, and we need rules of professional conduct. So that's a whole different doctrine. Here we go. Duh, Clay. Got it. Boom. All right, here we go. Rules of professional conduct, section 4.1, truthfulness in statements to others. So, in representing a client, a lawyer shall not knowingly make a false statement of material fact or law to a third person. 2. Fail to disclose a material fact to a third person when disclosure is necessary to avoid assisting a criminal or fraudulent act. And we go to B. The duties stated in this rule apply even if compliance requires disclosure of information otherwise protected by rule of professional conduct 1.6. So we'll also go to rule of professional conduct, people, 4.4. And if you're following me, I'm bringing you through these rules because these are rules that determine the truthfulness of statements when attorneys submit them to the court. That is how you have to attack attorneys' misconduct if you're dealing with a domestic violence situation that you can't control. The best thing you can do is find a way to legally challenge the things the attorney is doing by using the language and the regulations against him. Going into court and just being mad and saying, yo, that bitch is lying, that's going to make you look crazy. Take it from somebody it happened to. Going into court, sucking your teeth, being anything other than what I'm trying to be right now, people, is going to get you nowhere. You got to know what to say. That's the only way a judge is going to respect you, people, because it's not a game for dummies. It's a game for the informed. You have to know what you're talking about. So if you're dealing with an attorney who may be submitting false records to a district attorney, or dealing with an attorney who may be submitting false documents to family court, you are charged with the task of what's called impeachment. Impeachment involves challenging somebody's credibility. So basically, by impeaching them, which is a word a lot of people might be familiar with Trump, you would have to challenge them legally to the fact of what they're doing or saying. So if an attorney, let's say, like I was just reading, decides to make a false statement of material fact, something like that would be that you stole something, something you did, some fact that they're issuing into the case as a material fact. If they make a false statement of that to the court to falsely deceive the court, that would be a violation of rules of professional conduct 4.1. And rules of professional conduct 4, respect the rights of third person. In representing a client, a lawyer should not use means that have no substantial purpose other than to embarrass, delay, or burden a third person, or use methods of obtaining evidence that violate the rights of victims. So that also means that a lawyer can't go and make false statements to a court. A lawyer can't go and do things that they know is going to embarrass a person for absolutely no cause other than to get a fair verdict or a fair decision or a biased decision for their client. Now, the reason I happen to mention these offenses, people, is because I happen to recently go through them. I went through them, unfortunately, in my situation when an ex-girlfriend of mine got lucky, I seems, and found the most corrupt lawyer she could find. And this lawyer decided to help her, I would say, distribute her message that I was a diagnosed schizophrenic. Now, I've used it in several broadcasts, and people know that this woman used these documents, so to speak, to, she took a transcript from my father, basically. Actually, let's go there. Let's go there. We're going to show everything today because everything, this is important, people. This is where knowledge comes in. This is where learning is important, people. This is how you learn to beat back the devil, people. You beat the devil with patience, people. And definitely, Clay 50H. Yeah, there we go. Clay 50H, Bob. Let's get it all there. This is perfect. Ha, we got it all. One screen. So here we go. We're going to go here. So people may remember I made this broadcast. And in this broadcast, I showed how my ex was definitively showing records to try to gauge me as a diagnosed schizophrenic. Now, oh, damn. None of this stuff is up here? You got to be kidding me. Well, anyway, there we go, people. We were a little off. We're not going 10 minutes back. Unfortunately, people who listen, you heard what I was saying. All of that is on the New Jersey state of New Jersey's website. If you're there, if you're not, go to your state, look certain things up. You'll see a lot. So, diagnosed schizophrenia. Let's begin there. Diagnosed schizophrenia. These records were falsified by my ex to deceive the public into believing I had a diagnosis of schizophrenia. Now, why would this woman do that? I'll tell you why. Because in doing that, she could get an adverse verdict to a family court order of protection that was issued against her for violations she committed against me. Here, additionally, is the actual original transcript this woman found, which is public record, so I'm going to put it up. I'm not violating my father's rights or anyone's rights by putting this up. This transcript is public record. It's from a lawsuit he had 20 years ago up against some state agency. I don't know who it was, but basically, this is the transcript. As you see, I'm going to go through this transcript from page 1. We're going to go all the way down to page 8 because the only thing that matters is page 8. But in every page before this, people, I actually want to blow it up because I'm wrong. There it goes right there. So on page 6, actually, this is the same page as this. Let's go back. No. Let's go. It's so annoying. How did we do that? So we're going to go. So that sucked, people. I made the mistake again. I did it again, people. Damn. But it's all right. We're going to fix it right there. I think that's it. Yes. There we go. So here we go here. This is the diagnosed schizophrenic page, people. This is the original transcript of that document. This is a fine script my father had. He had a lawsuit going on. The city of New York does what's called the 50H lawsuit. If you've ever sued the city, the police, New York City Housing, any city agency, you have to do what's called the 50H transcript or a deposition of what happened. So my father did the one of that. I think he sued the MTA. He sued somebody. But in any event, he had to do a 50H disposition. In accordance with public record and FOIL law, they made it public record. My ex-girlfriend, Francina Evans, found this transcript and decided to post it to social media and edit the top of the page that had any identifying information from him, which you see right here, and cover it, as you see there. She covered it and only left out the part where you could see SSI and mental disorder, schizophrenia. Now, in this document, this is the unedited document here. Let me share that tab. So right there, in doing this right here with this public records transcript, editing it so like this to include diagnosed schizophrenia, like she did, Miss Francina Evans, she committed what's called a New Jersey records fraud, which is a Title IIc offense. Let's go to records fraud in the state of New Jersey for you guys real quick, because I like to educate. I like to empower. So for the state of New Jersey revised statutes, Title 2C, New Jersey Code of Criminal Justice, Section 2C 21-4, falsifying or tampering with records. Except as provided in subsection B of this section, a person commits a crime of fourth degree if he falsifies, destroys, removes, conceals any writing or record or utters any writing or record knowing that it contains a false statement or information with the purpose to deceive or injure anyone or to conceal anything wrong. So, people, this is what my ex-girlfriend did. This is actually what she had to do to get any type of leeway in her trial. She falsified the medical records of my father, and then she put them online and made 35 videos where she called me a diagnosed schizophrenic. In those 35 videos, distributed through 3 social media platforms, I'm sure thousands of people saw them. Now, what the real problem is the attorney of this woman. The attorney of this woman, the unethical black woman she is, decides that she's going to help this young girl out because she probably just didn't like me. I don't really care. It is what it is, people. Sometimes people are just not going to like you. What can you really do? So this woman, anyway, decides, you know what? She's going to help my ex-girlfriend do everything she can to get off with this crime. So she decides to help this young girl distribute her false message claiming that I'm a diagnosed schizophrenic. So for purpose of this broadcast, you see before you an email edited, of course. We don't want to show her email address so she can say I'm violating her privacy rights. That's important. I try to be careful with that now, people. Knowledge is power, and I'm aware. So this email is from the attorney of my ex-girlfriend, Cynthia Hardaway. I will say her name because I have written many, many ethics grievances against her, and I'm definitely suing her. If you're watching, Miss Hardaway, I'm going to file a civil suit against you because you definitely violated my rights in what you did here. I am forwarding these new videos from yesterday where your alleged victim is now going after Miss Ventola, calling her a racist white fat bitch. which I did, people. I was angry at the prosecutor, so I did refer to her in her misconduct and her physical appearance as a racist fat white bitch. It was wrong, it was rude, it was obscene, it was disrespectful, and it may have hurt her feelings. But with the protections of the First Amendment considered, people, it was not illegal. So even though this woman contacted the prosecutor's office and said this, truthfully speaking, her reporting this was just her trying to infringe on my First Amendment protections, which actually worked because what she did by reporting this forced this unethical prosecutor to use the information provided in the email I'm about to show you and try to put a fictitious case on me, which she's about to get a hell of a surprise for, people, because now she's made herself personally liable to a lawsuit for taking false information out of a prosecution and trying to have the victim charged in her own separate offense. This lady did the stupidest thing any attorney. I don't know, people. These people really thought that I was a stupid black man. They made a hell of a mistake messing with Clayton. And I'm pretty sure I'm in danger, people, but life is danger. I've been in danger my whole life, people. You got to live a little bit. So that's what I'm doing. So to continue, Mr. Howard is becoming increasingly more angry, violent in his speech, and unhinged. At this point, I am concerned about everybody's safety, including Miss Ventola. The fact that he puts all of this on public forum demonstrates he is not concerned much about the consequences, people, because the truth is there is no consequences for speaking on the public forum. That is what this great country is about, the rights of the First Amendment and free speech. That's why people can go on TV and call President Trump an asshole, because they believe President Trump is an asshole. I might not think President Trump's an asshole, but there are people who literally say online that President Trump's an asshole. They call him a woman beater. They call him a woman violator. They call Trump horrible things online. You don't see the Circuit Service kicking in people's door because they're saying things about Trump. People are entitled to free speech. They can say whatever they want, especially about people they feel that have wronged them. It's your legal right to villainize someone who you think has wrong. No one can stop you from doing that. Now, it's wrong to defame and slander people if they've done nothing to you. But if someone's actually done something to you wrong that you can justifiably prove, you have every right to say whatever the hell you want about someone. And yeah, it may be obscene, it may be rude, it may hurt the other person's feelings, and it may be inconsiderate. But as long as it doesn't infringe on any illegal activity, people, it's not wrong. It's protected by the First Amendment. And so was my content. But this woman allowed her personal preferences to get so involved in her prosecutorial duties. She used this insult to lock me out of my prosecution. And this is why my offender was acquitted, because I, as the victim, was totally locked out the prosecution by this email. Mr. Howard is becoming a priest. Oh, okay, that was there. The fact that he put up, we was there too. My client also tells me Mr. Howard may have a documented mental disorder for which he receives SSI. People, that is the key. Because now we need to go back and we need to highlight, people. We need to go back and we need to go here. People, again, this is the fictitious document created by Francina and all of the 35 videos she made claiming I was a diagnosed schizophrenic off a transcript she stole that I previously showed from my father. He's not late. He's not dead. Forgive me, people. And I'm going to show that again. Here is that transcript, people. This is the very transcript that we are talking about. And as you can see, going through this transcript, it's dated August 11, 2015. So, people, it's almost 10 years ago. Let's see if you see my father's birthday in here, which I believe you do. Okay, Clayton Howard, 819 Post Avenue. But he doesn't live there anymore, people, so it's okay. Where's your date? What's your year of birth? 1962, people. The transcript had all of my father's information with it. Forgive me, Father, if you're watching. I'm doing this to prove a point. What's this? May of mental disorder, people. It was the 6th page of the transcript. Here it was, his date of birth, where he lived. His year of birth was 2 pages before, right here. His year of birth was on page 4, and the mental disorder was on page 6. People, there's no way that my ex-girlfriend, Francina Evans, didn't see this transcript complete and know that this was not me. But people, she didn't care. She knew that by falsifying this transcript, she could use it against me to achieve an objective. So, people, that's exactly what she did. She used this attorney who is unethical, and I'm going to be quite honest, this attorney's a piece of shit. I don't care if she doesn't like it. She's a piece of shit. So she goes and she notifies the Essex County Prosecutor's Office that I may have a documented mental order. Now, the truth is I don't. This woman falsified records she found from my estranged father. Now, additionally, she sends the very page that I had been reporting to the prosecutor's office using that Francina was using editing software to edit and snip together videos to make me appear threatening to other people. She sends these to the prosecutor right here, people, and there you go. That's it. So she sends all of this to the prosecutor's office. So after that, people locked me out of the office. How do we deal with this attorney's misconduct? Well, people, in the fact that that attorney did that, what she did was violate my rights in several ways. One, she interfered with an act of prosecution by involving false information that had been doctored by her client to the prosecution in order to have a bias created against the victim. Remember, people, remember from what I just said about the rules of, excuse me, professional conduct. Oh, actually, I think it was, no, I'm wrong, people. I think it was misconduct, section 8.4. And I believe it was G, people, that an attorney who causes someone to be discriminated against for mental illness or anything, people, is guilty of misconduct. Now, people, I don't have a mental illness. But what this attorney did was create a mental illness with false information from her client. So I would be discriminated by law enforcement in the court. And in doing so, she is now guilty of misconduct under New Jersey Rules of Professional Conduct 8.4. So people, I filed motions and police reports against her, people, because again, even the fact that she's willingly distributing falsified records, people, she's guilty of records fraud also. She's complicit. And so is my offender. So people, in having the knowledge now to deal with the people who are trying to hurt me, I have learned a couple of things. One, it takes some patience. The game is not for the quick people. It's for the swift. It's not for the quick. It's not for the swift people. It's for the people who got the energy to go for the long haul. And it's not for the lazy either. Unless you got a shitload of money to deal with this, and I understand why it takes a lot of money to deal with problems like this now with relentless offenders. Because the truth of the matter is, this is a lot of work. I could get why a lawyer don't want to do this for free. I understand now why family court attorneys take forever to answer claims, because people doing this to people all the time, yo, all the time, every day in family court. I'm sure there's thousands of cases daily where people like myself are brought to court and falsely reported, falsely arrested, lied on, fighting cases, trying to get their children back because their daughter's mother or their boyfriend is mad they're with somebody else. People, domestic violence is jacked up. But as people who have to become better, we got to learn a way to fight it so we don't become the offender instead of being the victim, especially if we are the victim. So when you get into a situation where you have this conduct, you have to find ways to submit this to the court in what's called a motion. And the motion is probably going to be an order to show cause, because the order to show cause is the way you can immediately get into court to show a judge what's going on, hoping to quickly bring about an action, which is if you're requesting relief, let's say to get the attorney removed, then you would want that order to show cause, and you may not have to do it in your state. You may be able to combine the two, but in the state of New Jersey, I know that you have to have you have to have a separate motion to have attorney removed other than the order to show cause. So what you would have to file is an order to show cause, basically showing the court cause or proving to the court that this happened. You have to give the other person a chance to respond, because people, it's supposed to be a fair process for both sides. So just because you can prove they lied, it doesn't work and they're going to dismiss your case. No, you have to submit your case, excuse me, structured to the court, and then allow this person to respond. And this person is made to respond rather quickly, because in emergency actions, if the judge sees a serious issue, they do get you in there rather quickly. And you go before a judge, and the judge will either say yay or nay. I've been through these emergencies actions so far in my legal journey in the last, wow, this has been a crazy year, people. I have been through 4 orders to show cause, people, and I've only lost one. So I'm on a pretty good track record, people. I'm getting better. Every court order to show cause I just realized that every order to show cause I have filed since I took this class, I have won. For my daughter's custody back, for my parental rights back, as far as my visitation, and some other stuff that I got into effect. People, I won. So in winning, I'm realizing that something I'm stating in the law must be right, people. Um, Again, once you file these orders to show cause and you submit them to a judge and the other side replies, the judge is either going to give you a yay or a nay. The yay or nay is going to be the relief you request. And the relief you request, in the simplest dummy terms, is the shit you want from the court, which has to be within the court's power. It has to be something the court can actually do. So if the court can remove an attorney, that attorney is going to get removed. If the court can cite a victim with sanctions for lying, a court will do that. If a court wants to grant you back custody of your kid or immediately grant you access to your child because it believes you were wrongly denied access to your child, in order to show cause will do that. An emergency application will do things for you like that normal court proceedings will take months or even years to do. You just have to go through your state laws for whatever state court you're dealing with, either it's state or municipal, because this does apply to a municipal. And you have to figure out a way to get these courts to listen to you. Because walking in court and talking, people take it from somebody who went through this. God, people, this is going to be such a story to tell at the end of the day. Walking in the court and trying to talk to a judge ain't going to work, people. But if you can put on paper what that judge is supposed to tell you, because the judge ain't going to tell you. The judge don't even want to tell you. That's the truth. For the first time in my life, I think a couple of weeks ago, a judge told me a case that benefited me. But judges don't want to tell you. They expect you to know. And the opposing party damn sure ain't going to tell you. So if you sit there and you put all your eggs in the basket and let's say a court represented attorney who you're not paying, remember in life, people, I don't care what someone tells you. You They say the best things in life are free. Bullshit, people. You get what you pay for. So if you are in a legal situation and you got a public pretender, unless that person happens to be an extraordinary person, or they get to know you so well that they realize you're a good person and they want to do their job, 90% of the time, they're not really going to help you. But if you can prove to them that you're competent and they start to realize, like, wow, you're really going through something, then most good people, who are good people, because there are good attorneys, they will do their job as state representatives that were assigned to you. But most of the time, people, you're not going to find it. You're going to have to earn these people respect, and respect takes time to earn that you might not have unless you're a beautiful woman. I've noticed in family court, it really does work for women. Women get attorneys who are men, and men, men are men, people. Men like to smash. Some of these girls look good. The attorneys like to flirt. Some of them are men who ain't never been around pretty women in their life when they working in low-level family courts. So basically, being around these pretty girls is everything they can be for these attorneys. So these attorneys go all out for them, trying to make sure these pretty girls win because they ain't never been around girls this pretty. But whatever. You have to learn your rights. You have to figure it out because if you don't figure it out, you're going to be in an adverse situation. So I'm going to end this broadcast now because we're going on 31 minutes. I can't tell you how to file a motion, but I can tell you what I told you today, which is definitely beneficial. Learn the rules of the court, learn the rules of attorney professional conduct, how attorneys are supposed to act, the things they can legally do, how to cite them for misconduct, what motions or petitions you would have to file with a court if you realize or you can prove that an attorney did it. You cite what's called your exhibits with that motion because that's what it's called, people, and you pray for the best. Most most family courts now have what's called order to show cause general forms. They're really easy, literally walks you through the process, asks you what's wrong, what you're asking for. Again, people, you just got to take the time to structure it in a way where it doesn't sound like you're being accusatory towards the other person who may be the other party. Because again, even though it is a personal matter, the court don't care about that. The court only cares about legality. You have to prove legality. They have no connection to the personal drama we may be going through with other people. And it takes real time and maturity in this stuff to realize that these people don't care because they're doing it every day. It's not that they don't care about you. It's that they're doing 10 to 15 of these shits every day, 20 of them every day. So they become what's the word? Desensitized to the type of stuff that we're going through. So the only way to really get through it is to sit back, stay calm, and educate yourself a little bit, people. And then you might be able to get out of here. And one day you might be free too. So we're going on 34 minutes, people. I got to get off. But on behalf of being an informative, educated brother who is trying to help other people stay informed and empowered, my recommendation to you as a victim is you are going through a situation where you have an attorney who happens to be representing your offender who is trying to lie on you, file false documents, drag out the court process. Look through your state's rules of professional conduct. Check out the state's rules of judicial conduct. These are the conduct and the God, I can't say. These are the rules that govern attorney misconduct. The rules that God damn, why am I stuttering like this? These are the rules that determine attorney misconduct. The rules that determine how attorneys are supposed to act, attorneys and district attorneys. So learn those rules, learn the court proceedings, and then figure out a way that you can structure those to get those before a judge. Without arguing, you can't call the judge's chamber. You can't email the judge, people. The only way to get in front of a judge is to learn how to do it in writing. So take the time as a victim, learn how to do it in writing, learn the rules of how attorneys and prosecutors are going to act, then apply those to the rules of the court, and you're on your way. So on behalf of Operation Rock, thank you this Saturday and have a